Hello LiveLaw viewers and welcome to Courts Today. Here are today's top legal headlines. Supreme Court Collegium has recommended transfer of a Delhi High Court judge over cash recovery at his home, and further action as per in-house procedure is under consideration. The Karnataka High Court has reserved orders in a plea to ban Proton Mail in India. Punjab and Haryana High Court has imposed 1.5 lakh cost on Haryana Public Service Commission for rejecting a judiciary candidate's SC certificates for not being in a particular format. Rajasthan High Court has reiterated that compensation awarded as consortium is also payable to siblings of the deceased apart from parents. The Delhi High Court has granted bail to Unitech founder Ramesh Chandra in a money laundering case on account of age-related infirmities. And the Gauhati High Court has directed Assam government to show steps taken to combat problem of rampant hill cutting. I'm your host Urvashi Chauhan, bringing you the latest legal updates that matter the most. From key court rulings to significant legal developments, we have it all covered for you. Watch till the end for a complete roundup, and if you find this update useful, make sure to like, share and subscribe. Starting with an important and a serious update. The Supreme Court has recommended transfer of Delhi High Court Judge Justice Yashwant Verma following reports regarding discovery of huge amounts of unaccounted cash in his official residence. A large amount of cash was discovered at Justice Verma's residence when firefighters arrived to put out a fire. Justice Verma was not present at that time. The fire personnel took photos and videos of the cash and reported it to their seniors. The information eventually reached top government officials, who then informed the Chief Justice of India. As a result, CJI Sanjeev Khanna convened an urgent meeting of the Supreme Court Collegium yesterday evening to discuss the matter. Justice Verma is now recommended to be transferred to his parent High Court, that is the Allahabad High Court. Reportedly, the transfer is not the final step and is only a preliminary action, with the authorities considering further actions as per the law. The in-house inquiry procedure against the judge has been initiated. Let me tell you, as per in-house inquiry procedure adopted by the Supreme Court, when there are allegations against a High Court judge, the Chief Justice of India, after a preliminary inquiry, forms a committee of 3 Supreme Court judges to inquire into the matter after seeking response of the judge in question. Based on the report of the in-house panel, further action can be taken. Let me also tell you that a High Court judge can be removed from office only through an impeachment motion passed by the Parliament. No judge has been impeached in India's history, though some faced proceedings, but they resigned before the completion. I must also tell you here, the Allahabad High Court Bar Association has opposed the transfer of Justice Verma back to Allahabad High Court. In a letter to the Chief Justice and other judges, the HCBA criticized the Supreme Court Collegium's decision, stating that the Allahabad High Court is not a trash bin and that corruption is unacceptable. The association has now called for an urgent General House meeting on 24th March to decide further action. This issue was also discussed by the Rajya Sabha today. Vice President and Chairman Jagdeep Dhankad responded that he will take all procedural steps as required to address this issue. In the next update, the Karnataka High Court has today reserved its order on a petition filed by M. Moser Design Associated India Private Limited, seeking a direction to the Union government to ban use of Proton Mail in India. The petitioner has argued that Proton Mail, a Switzerland-based encrypted email service, allows users to mask their location and appear as though they are accessing the service from within India while remaining beyond the reach of Indian law enforcement agencies. The company contends that this poses a serious national security threat, particularly since the service has been used in the past to send bomb threats to schools in India. Citing examples of Russia and Saudi Arabia where Proton Mail has been banned, the petitioner asserted that India should take similar steps. The petition also stems from a criminal case filed by M. Moser Design, alleging that its senior female employees were repeatedly harassed through obscene and derogatory emails containing AI-generated deepfake images and other sexually explicit content. These emails were not only sent to the affected employees but also widely circulated among the company's staff, associates, vendors and competitors, leading to severe reputational harm. Despite an FIR being registered in November 2024, the company claims that no effective steps were taken by the police to track down the perpetrators. According to them, even though India has a mutual legal assistance treaty with Switzerland, which allows Indian authorities to seek cooperation in criminal investigations, the police did not pursue this route to obtain information from Proton Mail. During the hearing of this matter, the petitioners' counsel argued that under the Information Technology Act and its related rules, any digital service operating in India must either have its servers within the country or allow Indian authorities to access their data when required for legal proceedings. Representing the Union government, Additional Solicitor General Arvind Kamath acknowledged that while India has an agreement with Switzerland for legal assistance, only a competent criminal court can issue a letter rogatory to request access to information from Swiss authorities. He clarified that Ministry of Home Affairs or Ministry of Electronics and IT could not act independently in this matter. However, he assured the court that if a direction was issued by the Karnataka High Court under the relevant legal provisions, the government would comply. After hearing both sides, Justice M. Nagprasanna reserved the order, remarking that the issue was serious and required appropriate action from the central government. He observed that the petitioner was essentially urging the government to act through the proper legal channels and that the matter needed to be dealt with strictly in accordance with the law. Stay tuned for the verdict in this matter. The Punjab and Haryana High Court has fined the Haryana Public Service Commission 1.5 lakh for wrongly rejecting a candidate's application for the Haryana Civil Judge exam under Scheduled Caste category. This case involved Divya Kalia, who applied for Haryana Civil Services Judicial Branch Examination 2023-24 as an SC candidate. She submitted her SC certificate within the required time frame, but HPSC rejected her candidature due to minor formatting issues. The commission claimed that the registration number was missing and that the date was mentioned at the bottom instead of being at the top. Despite clearing both the preliminary and mains written exams, she was not allowed to appear for the interview. The High Court found the rejection baseless, stating that the errors were insignificant and should not have disqualified the candidate. The court observed that while the registration number and date were not mentioned on the top left side of the certificate, the date was clearly stated at the bottom left as July 11, 2016. The bench further stated that such minor errors should not impact a candidate's eligibility and that such actions unnecessarily burden the judicial system. The court emphasized that it was the responsibility of the issuing authority and not the candidate to ensure correct formatting of the certificate. Thus, the bench of Chief Justice Sheel Nagu and Justice Sumit Goyal set aside the rejection and directed the Public Service Commission to process the candidate's application. Additionally, it imposed a 50,000 rupees fine payable to the petitioner and 1 lakh penalty to be deposited in the Poor Patients Welfare Fund. The Rajasthan High Court has ruled that compensation awarded under Motor Vehicles Act for loss of consortium is not limited to the parents of a deceased accident victim but is also payable to their siblings. The court emphasized that while no amount of money can fully compensate for such a loss, it is the court's duty to ensure just compensation. This ruling came in an appeal and cross objection concerning the death of a 1.5-year-old girl who was run over by a school bus due to the rash and negligent driving of the bus driver. The Motor Accidents Claim Tribunal had initially awarded 1,75,000 with 9% interest per annum, but had not granted compensation for consortium to the siblings or for funeral expenses. The family of the deceased challenged this, arguing that the siblings were also entitled to compensation under non-pecuniary heads. On the other hand, the insurance company contended that the consortium compensation is granted only to the parents in cases where they are alive. Rejecting the insurance company's argument, the High Court referred to its previous ruling in Shriram General Insurance Company Limited versus Jethmal, where it had granted consortium compensation to the deceased's brother, stating that emotional loss should not be measured based on financial dependency. The court also cited Supreme Court's decision in Sadhna Tomar versus Ashok Kushwaha, which recognized the right of siblings along with parents and spouses to claim consortium. As a result, the court has enhanced the compensation to 2,13,000, which included 1,45,000 for consortium and 18,000 for funeral expenses, along with 9% interest from the date of filing. The court here also heard an appeal by the bus owner and driver challenging challenging the tribunal's decision that had exonerated the insurance company from the liability. So the tribunal had ruled that since the driver only had a license for light motor vehicles and not for transport vehicle like a school bus, the insurance company was not responsible for the claim. But the High Court has overturned this finding, relying on Supreme Court's judgment in Bajaj Alliance General Insurance Company Limited versus Rambha Devi and others, which clarified that an LMV license holder is legally permitted to drive a transport vehicle without additional authorization. Consequently, the High Court held that non-applicants, including the bus owner and driver, jointly and severally are liable to pay the enhanced compensation to the claimants along with interest. The Delhi High Court has granted bail to 86-year-old Unitech Group founder Ramesh Chandra in a money laundering case registered by the Enforcement Directorate. Justice Jasmeet Singh ruled that Chandra falls within the category of infirm under proviso to section 45(1) of PMLA, exempting him from the twin conditions for bail. The case against Chandra stems from multiple allegations of financial fraud and money laundering. Several home buyers accused Unitech promoters, including Ramesh Chandra and his sons Ajay and Sanjay Chandra, of cheating them by collecting large sums for real estate projects but failing to deliver the promised homes. Following complaints, 62 FIRs were registered by the Delhi Police's Economic Offences Wing and the CBI. The Enforcement Directorate later filed a money laundering case in 2018, alleging that the funds collected from home buyers were misappropriated and laundered through various entities. Chandra was arrested in October 2021. Now, the High Court noted that Chandra had been on interim bail since August 2022 on medical grounds without misuse of his liberty. It highlighted that the trial involving 17 accused, 66 companies, 121 witnesses, and over 77,000 pages of documents was unlikely to conclude soon. Chandra, who suffers from cognitive impairment, pseudo-dementia, and frequent falls, was deemed to require constant monitoring, which the jail authorities could not adequately provide, and thus the bail was granted. However, the court clarified that the merits of the case would be determined at trial. And lastly, the Gauhati High Court has asked the Assam government to provide details of steps it has taken to stop illegal hill cutting in Gauhati and other parts of the state. A bench of Chief Justice Vijay Bishnoi and Justice N. Uni Krishnan Nair was hearing a case about hill cutting and encroachments which led to floods and landslides. The court has asked the Advocate General to submit a report within 4 weeks on the state's efforts to tackle this issue. In response, the Assam government stated that it is working on a GIS-based comprehensive drainage master plan and conducting surveys to map stormwater drains. Senior Advocate K.N. Chaudhary, appointed as amicus curiae in this matter, told the court that a retired IAS officer has given some suggestions, which include that the government should stop giving permission for hill cutting and construction in low-lying areas for 3 years until flood control measures are in place. Encroachments should be removed from reserved forests and large-scale tree plantations should be carried out. A survey of temporary lands should be done and large constructions should be banned there. The court has urged the government to seriously consider these suggestions while preparing its master plan. The next hearing in this matter will now be in 4 weeks. Stay tuned.